briefing, there was a large panel of ceiling that fell down and hit our client's head as she was going up the staircase. There's two big issues. Excuse me, there's only one big issue before the court right now. The defense is refusing to provide the maintenance record requests from the adjacent rooms to that ceiling panel. They provided the maintenance records request from our client that our client made, but they haven't provided any of the maintenance record requests from those other three tenants that are adjacent to it. And so that's why we're seeking the court's intervention. And then the second, less important request is that though the defense has provided the identities of those individuals that occupied those other three rooms, they have not provided the contact information for those individuals. I know that the defense is arguing that the temporal scope of the request is not proportional and stuff like that, but this is a ceiling collapse case of a large panel of ceiling that undoubtedly took time to develop. It's not like a slip and fall case where, you know, maintenance record requests would be for the day of or something like that. It's a huge panel of ceiling that came down. They're also arguing that they recently took over the property prior to the incident taking place. I believe that they said they took over the property in November of 2021, and the incident itself happened in the middle of December of 2021. And so they're saying that the maintenance record requests that we're seeking, because we're seeking documents that are further than 1 month prior to the incident, they're saying that those third-party documents are not proportionate as well, and that they shouldn't have to go get those documents from the third-party entity. Our response to that is plainly, if they took over this property 1 month before the incident took place, it is extremely probative what they were on notice of whenever they were doing a due diligence analysis of this property that they took over. And if those maintenance record requests from the previous entity indicate that there were issues with the subject ceiling, that is a liability that they were going to be accepting when they took over this property. And if that's the case, obviously we have to show that either they were on notice of or they should have been on notice of this dangerous condition, and those would be facially relevant.
Response?
Your Honor, just to clarify something, and Mr. Wagner, I provided on Friday the last known addresses of the tenants in the adjoining properties. Did you not get those?
No, we whenever I say contact information, I mean like phone numbers.
Oh, I'm not even sure we would have that. But Your Honor, moving to the primary issues here, Your Honor, plaintiff is seeking maintenance portal requests for December 15, 2018 through February 15, 2022. This incident occurred on December 15, 2021. Plaintiff's argument in its motion for needing to go that far back was the time notice rule. Your Honor, however, records from 2018 are not going to be relevant for the time notice of an incident that happened 3 years later. As to plaintiff's
Is he limiting to just issues with the ceiling, or is he trying to get any type of maintenance records?
No, it's any type of maintenance records, Your Honor.
So I tend to agree with Mr. Wagner that it would take a while, I would think, for any issues like this to develop. If there was like leaking in the ceiling or whatever, that would be anything dealing with any type of maintenance to the ceiling. I think 3 years back is reasonable. I don't know why, let's say there's a plug that's not working and there's maintenance for that, why you would need that far back. And so I guess my thought is that the time frame isn't a problem, at least prior to the accident. I don't know why you need after the accident necessarily, but prior to the accident related to the ceiling, other things I'm not sure why you would need.
I can respond to both points, Your Honor. We are happy to limit the request for the past 3 years to issues dealing with the subject ceiling. Honestly, we just thought it would be easier for the defense to go get 3 years of maintenance records with no sort of I guess threshold criteria. I think it'd probably be easier to just search these 3 units for these 3 past years, hit print and produce those documents than it would be to go through all 3 of those units, sieve it, and then.
So I'm going to order 3 years related to any type of maintenance requests to the ceiling.
Okay.
Your Honor.
Let me go to the next issue. You do need to give the rest of the contact information for these tenants. So if you have phone numbers, email addresses, you need to give those. What was the other issue, Mr. Wagner?
It was the contact information, and then there was the 1 year after it. And Your Honor,
Why do you need that?
That would be for it's not necessarily for subsequent remedial measures. It'll be for things like we want to know about feasibility of precautionary measures, because right now the only evidence that we have of communications between the tenants and the entity is the kind of the in-room maintenance requests. And we want to know if there would have been something more appropriate for common area repair requests, which is where this incident happened. This was a common area where that subject ceiling fell. And the defense is arguing that these in-room maintenance request portals are the sole means of communication between our client.
I'm not sure I'm following you on that.
So
we're just talking about the year afterwards. Are you talking about a different area now, or?
Yeah, we're talking about, well, as Your Honor knows, subsequent remedial measures are not admissible for any of the negligent culpable conduct or anything like that, but they can be admissible for to demonstrate the feasibility of precautionary measures, which is why we're seeking it. And so if there were a maintenance record request portal for common areas, as opposed to just domesticated areas, for common areas, I
don't why I'm not sure why you're going into that area of common areas. How does that relate to the year afterwards? That's what I'm not getting the connection.
Yes, Your Honor. So the incident occurred in a common area.
Okay, that explains it. Okay.
My apologies, Your Honor. It occurred in a common area. And so our idea is if there was a maintenance record request portal for common areas, as opposed to just the domestic areas within the property, we think that this probably wouldn't have happened.
I'm not sure how that goes to the issue the year after, but all right, the year after is fine. It's not, isn't necessarily admissible, but it is probably discoverable. So did you want to say something else, Mr. Cox?
Yes, Your Honor. I just want to clarify something to make sure I understand your full order. My client is the operator of the property, is not the owner. And they took over this property in an arm's length transaction on November 5, 2021. We have no relationship with the prior operator of the property.
You have to produce anything under your care, custody, or control.
Yes.
And so you also need, if he's requested it, give them the name of the prior operator. If you took over the same maintenance portal and you have those documents, you need to turn them over. If you don't, and you don't have access to any of the records before then you need to let them know who the prior operator is. You may need to sue the prior operator, Mr. Wagner. I don't know.
Okay, yes, Your Honor. We think it would be highly unusual if they did not get a chance to review or have access to those maintenance records before then, but understood.
Let's see. All right, you need to produce these within 2 weeks. Mr. Wagner, go ahead and give me an order that details all my rulings. It needs to say at the beginning of the order that this was heard on April 17, 2023. You need to share a copy of the order with Mr. Cox. And then you need to email Rhonda, my court coordinator, as well as e-file that by the end of the day on Thursday.
Yes, Your Honor.
Anything else, guys?
No, Your Honor. Thank you very much.
That'll be 2 weeks from today, Your Honor. Not when
2 weeks from the day I sign the order.
Okay. Thank you, Your Honor.
All righty, you guys have a great rest of your day.
Thank you, Your Honor.
Okay, our next hearing is,
Judge,
yes.
hey, sorry to interrupt. I was able to get in contact with Methodist. They gave me a phone number that I tried and immediately led to nowhere. And so I would ask Judge, maybe if we could set up some sort of status conference that way I can give them the email and to the email and to the phone number. I'll keep badgering them to set for the date of the state status conference. And maybe that would work.
Who's
Judge.
your opposing counsel on this?
I am.
All right. So how does next Monday, do you want to do, I hate to do this at 9. What was the cause number on this case again? Was it 9434?
Judge, it is 1912900.
Rhonda, we're going to give them 30 extra days. And then how about a status conference on this for next Monday at, let me just double check something real quick. Yeah. How about Monday at 10? Does that work okay for both sides?
I can have someone in my office appear on our behalf, Your Honor. I actually have a minor prove-up hearing at 10 at the courthouse. So I can
Would you prefer to do in the afternoon that day?
that would be fine. I could do the afternoon.
Mr. Valencia, does that work for you? Do you want to do like 2 o'clock?
I do have trial settings, Judge, but I mean, I'll make sure that someone's here and is aware of the issues related to it that can handle it, Judge.
All right, let's go ahead and set that at 2 o'clock next Monday, Rhonda.
Sounds good. Thank you, Judge.
Rhonda, did you get that?
Yes, Judge, I got it.
All right, go ahead and reset the DWAP for 30 days and then set a status conference on this for a week next Tuesday. Next Monday at 2 o'clock.
And will the status conference will we have a specific Zoom or will it be the
It'll
same?
be the same Zoom link. You need to send the Zoom link to the Methodist, and I want to talk to someone from Methodist.
Will do, Judge.
All right, thank you so much. We'll see you next week.
Thank
Sounds
you, Your
good,
Honor.
Judge. Thank you.
All right, is anyone here on Encore Electric Delivery Company versus Simpson?
Yes, I am, Your Honor. Good morning.
Good morning. All right. Wow, Odyssey is not working well for me today. Okay, so can you go ahead and announce the cost number and case name, Ms. Dukes, of this case? And Tony, let's go on the record.
Yes, Your Honor. This is for cause number DC 22-16596 on motion for substitute service. Jordan Dukes for Encore Electric Delivery Company. Your Honor, in this case, we have tried to serve the defendant with personal service. We have tried several addresses. All of them have come up short. We have also tried to find the defendant via social media. However, there were no indicators throughout social media that would point to the defendant substantially to allow a alternative service by social media. We also checked to see if the defendant was in jail. The defendant is not in jail, so we are asking the court to grant a motion for substitute service via publication on those grounds.
All right, give me 1 second. So explain how this accident happened or this case happened. Is this one where somebody cut the line?
No, I believe, and give me 1 second. Yes, this is where a vehicle struck a pole and damaged the pole. So Encore Electric Delivery, we own the poles and the very top attachments of the lines. So our lines don't get snagged. It's usually the communications lines that are below that kind of hang low on the pole. In this case, the vehicle struck the pole that we own. There was no underground damage or any overhead line damage.
Rhonda, I'm having problems with Odyssey right now. Can you go ahead and print out this order, put that I approve it and put it in the stack?
Yes.
All right, have a great rest of your day.
Thank you, Your Honor.
All right, thank you. And then our next hearing, Rhonda, is there's a Yol Zahir and Udu Oko. No, okay, there's a Yol Zahir.
Yes, that's me, Your Honor. I'm filling in on this case as well on the dismissal docket. It's 22-09434.
Okay, what? All right, what's going on with that one?
We just need a couple more weeks to file a motion for default judgment because there's been service but no answer.
That's 229434, is that right?
Yes, Your Honor.
George Onucci.
Correct.
Yeah. All right, we'll give you 21 days on that. You got, this case is pretty old, so you guys need to get this done, okay?
Will do, Your Honor.
All right, thank you. Have a great rest of your day. Rhonda, when is our next hearing?
At 10 o'clock.